Hi, it's John from the team at HR Stories. Normally, Chuck Samicki and I would start chatting about what is happening in HR at the top of the show, but we decided to do something different. As HR professionals, you know that keeping up with the employment law is critical to doing our jobs well. So in today's episode, we're going to play a recording of a webinar that I did on updates employment law titled, What Did You Miss? The Stories That Are Changing HR. Enjoy and stay tuned for a special announcement at the end of the episode. Good afternoon, good morning, welcome. This is a workshop, seminar, webinar that we put on, the team at HR Stories puts on probably about quarterly. And it's so funny because yesterday I was out in Detroit and I was doing a workshop for people that were new to HR, right? So they were all new to HR. And one of the things I said to them is you got to pay attention to what's happening in employment law, what's happening in terms of best practice with HR, because they're constantly changing. And as I was preparing this webinar, things were changing, right? And those things were happening. And I'm like, oh my goodness, the court did this and the court did that. And so I'm hoping to get you all that information. Again, my name is John Thalheimer. I am the CEO, partner, and leadership coach at HR Stories. I also co-host the HR Stories podcast with Chuck Samicki, which comes out every Tuesday. And we're also co-authors of the Ultimate Book of HR Checklist. So if you haven't listened to our podcast, highly recommend it. Lots of great information. We're always sharing information about what's happening. It is a good way to stay up onto what's happening. And so the format today is going to be pretty self-forward. I got a bunch of topics and I want to do it in 3 different segments. I want to do a flashback. Right, so I'm going to talk about the changes to the I-9, Pump Act, the Pregnancy Workers Fairness Act, religious accommodations, and then I'm going to get into today's news, what we should be paying attention, what's happening right now in terms of HR, so minimum wage, OSHA, NLRB, Department of Labor, final ruling, and then we're going to do a little crystal balling, right? We're going to be talking about how these are the things that we see on the horizon that you may be wanting to pay attention to. So final ruling on the white collar exemption. Dun, dun, dun. The EEOC enforcement guidance on harassment. What does that mean? OSHA worker walk-around representative, FTC rule banning most non-competes, artificial intelligence and remote work. And we're just going to talk about those last 2 topics because I think they're important, something that we should be addressing in our work and all that kind of stuff. So let's start with these flashbacks. But before I do that, I do need to give the webinar disclaimer, right? Always check with your employment lawyer, your HR consultant. Here's why. Every one of your businesses are different. Every one of them is different. And your laws are going to reflect geographic location, your industry, number of employees. All of those things are really important. So making sure that you address them and pay attention to them is great, right? So kind of doing that. So it's hard for me to give specific guidance until I know you better and I know what's going on in your organization, where you work and all that kind of stuff. So this will be generic, but just pay attention and kind of think about, oh gosh, we need to look at that. We need to do that. All right, so let's go to 2023, do a little flashback here. Let's talk about some of the laws that impacted us in 2023. And I'm not going to go into a lot of detail, right? Because hopefully you already know them. And if you don't, I just want to put them on your radar and go, oh, I need to be thinking about that. Gosh, we haven't implemented that. We haven't done anything with that as well. And so, of course, the big one was changes to the I-9. And so as of August of last year, there's a new I-9, so there's a new form. I like the new form. It kind of reduces the paperwork that we need to do. It reduces all that information down to 1 page. And then they have supplement ones that we can fill out in there. To me, I think the biggest change when I look at it is 1, the form's completely different. But now, like, we don't have to put NA in there anymore, which I think is a big change for me. They changed some of the wording. And then the other big change is they do now allow us to inspect the employee's documents remotely if, 1, they are not coming into your brick or mortar building. Right? So if they are definitely not, they're a remote employee, they will never come in there. That's one thing that you need to be paying attention to. And the second thing is you need to be using E-Verify. So E-Verify is a secondary program that you can use on top of I-9s, not in replace of, but on top of I-9s to check somebody's authorization to work in the United States, their identity and their authorization to work in the United States. And so you can do it, but you have to use the e-verify process to do it. And then it's just basically showing the video and going through that. And so, again, important kind of things to remember, but just making sure that you do that. So that's the I-9s. We should all have been moved over to the new I-9s. You should have moved over at least before November 1st. But after that, you definitely needed to be using the new form. So just make sure that you're doing that. If that's not your responsibility, check with your team, go, are we doing this? The second thing was the Pump Act. And so the Pump Act came out of April about a year ago, last year. And really what the Pump Act was an extension, right? These laws were already in place, but this became an extension of the Pump Act. And so it increased the number of people that were covered by it. And it became very specific on what an organization needs to do for moms in the workplace. And so we need to make sure that we give them breaks to express breast milk. And we need to give them a location. That location is not the bathroom. In fact, Chuck and I on the HR Stories podcast, and I think it's coming out next week, or it came out this Tuesday, it came out today. I think it comes out next week. And we did an episode around two individuals, two moms that were working at two different McDonald's. And so you think about a McDonald's and the size of McDonald's and how they use their space, they don't really have room set up for a person to express breast milk. There's not that place to do it. And so McDonald's, the two franchises, not McDonald's corporate, but the two franchises got in trouble. And so we talk about that in our podcast. So definitely check out that episode if you're not aware, and we go through all the episodes and things to do and making sure that we do that. And now the next thing we need to be paying attention to is, of course, the Pregnant Workers Fairness Act. And this provides for accommodations for pregnancy, childbirth, and related medical conditions. And so the way I describe it to my clients, the way we talk about it, is it's very similar to the Americans with Disability Act. If there's an individual and they request an accommodation, we need to provide that accommodation unless it's going to cause an undue hardship to our organization. So undue hardship is something that's going to cost significant amount of money or going to really knock our operations out. And so in most cases, I think we can arrange that. I worked for a company where in one particular area, we did not allow any liquids. There was a lot of electronics, so we didn't want any liquids in there. And people were working there for long periods of time. And so we ended up having pregnant workers that were working in that area, and their doctor said, look, they need access to water on a regular basis. And so we gave them permission to do that. We accommodated them that, right? And so again, those things can be simple, they can be complicated, but again, paying attention and doing that. And then the other one that came up that I don't remember if we had a lot of conversations about it. I know we talked about it a little bit on the podcast, but religious accommodations. So there was a court case where, and I can't remember the person's name, but it was against the United States Postal Service. And this individual wanted a religious accommodation. They wanted off, I think it was Sundays. They wanted off on Sundays because that was their Sabbath, that was their day. And so they had a sincerely held belief. And so originally they accommodated him because they just moved him to a different territory, and that wasn't having Sunday deliveries. But that territory then had Sunday deliveries. And so the Post Service said, oh, well, no, we can't do it because it would be a scheduling nightmare and we can't do it. And so this goes all the way up to Supreme Court. And Supreme Court says, look, it's not, unless it's substantial, right? Unless there's a really true substantial undue hardship that increased costs, increases difficulty, then you have to do it. And so one of the things we should have looked at in 2023 is gone through and go, okay, are these religious accommodations? What do we need to be paying attention to? And so just really thinking about that. So it's not like that de minimis, like, oh, sorry, we're going to have to change our schedule around. That's too hard. We really need to think through and go, does it really make sense? So that is really there. So there is obviously a little more religious accommodations that we need to be paying attention to. So really pay attention to this. So those are the 4 main ones that happened in 2023. So we should all be aware. We should already start influencing our policies and our workbooks. Our policies and our employee handbook should have adjusted. And so we should already be doing that. We should have already incorporated those in there. And so that leads us to 2024, right? What's happening today? What are the laws and regulations and things that we need to be paying attention to in now, right? What are those things, right? So number one, minimum wage increase, right? And so we should know that there were 20 states that increased their minimum wage in 2024. And they're listed on the slide. And so kind of knowing that, but also many cities and counties also raising their minimum wage. And so as an HR professional, I may work for an organization or I may not work for an organization that has minimum wage. But even if that organization doesn't have a single employee being paid at minimum wage, we have to understand when minimum wage goes up, there's this upward pressure on salaries, right? And so if what happens is, let's say minimum wage right now, we know federally it's $7.25, but let's say our state raise it from $7.25 to $10. Now, all of those individuals that were making $10 an hour are going, wait a minute, what's happening here? They're doing the same work they were doing before, but they just got a $2.75 raise. I'm doing more work, more responsible work. I should be getting paid more. And so they ask for more wages, and that moves them up. And then the people above them want more wages, right? And so there is this, every time minimum wage goes up, there's this upward pressure on that. And it's so funny. So I was doing my minimum wage conversation in my class, my workshop yesterday, and I always use the Economic Policy Institute's minimum wage guidance because it has lots of great information. This is definitely a great resource to tap into. That's the Economic Policy Institute. You can go Google that and kind of put minimum wage in there. You'll find it. They have a lot of other stuff. But they had an article probably for the last 2 years that said why minimum wage should be $15. It now says why minimum wage should be $17. Right? And so I think there's this upward pressure. And so paying attention to that. It may not impact your state. In my state of Tennessee, we don't have a minimum wage. We just follow whatever the federal says. And so kind of paying attention to that and kind of looking at that. So that's number one. The second thing is OSHA, so the Occupation Safety and Health Administration, updated their workplace injury and illness reporting requirements. So as January 2024, OSHA requires establishment with 100 or more employees to electronically submit information from their OSHA forms 300 and 300 once a year, update the classification system used to determine the list of industries covered by the electronic submission there, and required an establishment to include their company name when making electronic submissions, right? And so again, most of us are we're already doing this, but there are some more industries that are asking us to do this and making sure that we're doing it electronically. So they don't want us to do it by paper anymore, and making sure that we go through the forms and submitting those forms properly. It's just something to pay attention to. So a lot of us may be like, well, we're not really in OSHA. I don't really need to worry about it. But other ones do. And so we always just want to make sure that we're covering that as well. We're going through that on there as well. So just making sure that you're doing it. All right. So now the National Labor Relations Board, I will tell you, out of all the government agencies, they have been the most active over the last probably last 7 months, 8 months. They've been really active. They've been really looking at many things. And I'm going to talk about joint employer ruling in a second, but there was also another ruling that I want to talk about. And we did talk about this on the podcast. And so recently they ruled that Home Depot had to allow an employee to leave BLM, Black Lives Matter, on their apron. They had to allow them to do that. They fired the employee for not taking it off. And they said, no, you have to reinstate that employee. That employee has the right to do it. Now, it wasn't as simple as that, right? What was behind that was this individual and other individuals were complaining about a racist and biased manager that was working in that particular Home Depot. Home Depot heard that and did talk to that manager and did discipline that manager, but the employees did not see any behavioral change. And so they started a protected concerted activity and talking to people and protesting and doing that kind of stuff, which was all protected. And so the National Labor Relations Board said under that concerted protective activity, which allows our employees to talk about salaries, talk about working conditions among themselves, they have that, that was acceptable to put BNML on their apron. Part of that was that Home Depot allowed them to customize and personalize their aprons, right? And so when you think about this, right, and so one of the things that I would go back to, and I'm looking at my policies in terms of dress code, what does my dress code say? How much leeway do individuals have on there? And so kind of paying attention to that becomes a really important thing as well. All right, so that's an extra bonus, just kind of throwing that in there for you. The National Labor Relations Board, right? And so they had the joint employer ruling, which started in February. It says an entity may consider a joint employer of another employer's employees if the two share or co-determine the employee's essential terms and condition of employment, even if it's indirect or reserved control, even if it's never exercised, right? And so even if it wasn't exercised, you could still be liable. So think about staffing agencies, think about unions, think about individuals that are being leased out to another company. Those could be considered joint employer. Well, guess what happened last week? And this is what I'm telling you. These things are always changing. Last week, a judge vacated that definition of joint employment and reverted to the 2020 ruling, which states substantial direct and immediate control, right? And so the ruling that the NLRB had said is, look, even if it's indirect or they're reserved or they don't really exercise it, they're going to still be joint employer. And then the judge sort of came on and said, no, we don't like that. We don't think that's right. And so we're going back to substantial direct and immediate control. So staffing agency, you're probably still a joint employer, right? Because you're directing, you're telling them this is when we need you to show up. And then the company is telling them what to do while they're there. So probably joint employer, less maybe in the leasing situation when you're leasing an employee in there. So here's the thing. We don't know at this very juncture whether the NLRB is going to challenge that ruling or not. And so paying attention, going, hey, I need to pay attention. I need to know. There's going to be more to come on this for sure. Right? So going to pay attention and looking at that, I think is important for all of us to do to make sure that we're up there and doing that as well. All right. So the other ruling that came out as of March, I think 11th, 2024. So the beginning of this week was the independent contractor ruling. Dun, 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 dun. And so the Department of Labor determination of independent contractor goes into effect. So what it did is, so let's go back in history. So back in when Obama was president, when the Obama administration was president, the DOL passed what they call the six-factor economic reality test. The six-factor economic reality test was a list of 6 questions that we had to ask to see if somebody was an independent contractor when it came to the Department of Labor. And then the Trump administration came in, the Department of Labor changed that. They rescind, they said, oh, we're not going to follow the 6 economic factor in total. We're going to focus on these 2 things, right? And I think it was control and the ability to make money or profit, right? And so the new ruling, the one that just came out in March, was rescind the rule of 2021 and returns to the totality of the circumstances of the economic reality test, meaning it goes back to those 6 questions. Now, for me, I will say that I had already been coaching my clients and the people in participating in my workshops, like stay with the 6. It makes more sense. You can really understand it. But there was some pushback and people were like, well, right. And so you want to pay attention. So what is the economic reality test? Number 1, is there an opportunity for profit or loss depending on the managerial skill? Right. And so that's the first thing we're going to look at and see, okay, is there investment by the worker and the employer versus the employer, right? And so how much is the worker investing? So think about a plumber that has their plumbing business. How much are they investing versus if I hire a plumber to work in my organization and I'm buying the tools and the materials and all that kind of stuff, that's more likely to be an employee versus that person that comes in and does all that other work. Is there a permanence of working relationship? So is there some assumption that this working relationship is going to go on, or is it on a particular contract? So as an independent contractor, a lot of times clients will hire me to come in and do a workshop in their workplace. It's just for that workshop. I'm not doing their training for the rest of the next 4 or 5 years. I'm doing that particular workshop for them, and so I'm an independent contractor. It would be different if they're like, "Hey, John, can you take over our learning and training and develop processes and do all that?" That would be different. I would end up being an employee. Nature and degree of control. This is a big one, right? So when we're thinking about independent contractors, we can really only tell them what we want. What are the results? What's the outcome we want? We can't tell them when to do it, where to do it, how to do it. We just need, hey, this is the results we want. This is what we want to get done, right? And so kind of looking at that, excuse me, whether the work performed is integral to the employer's business. Now, this is the one that is going to cause a lot of agita across the United States, because the big companies like Uber, Lyft, DoorDash, they will tell you that their drivers are not an integral part of their business. They are a software company. And so a lot of these gig workers, or the companies that are facilitating those communication back and forth between those gig workers and customers, are saying, wait a minute, they're not there, right? So our expectation when it comes to this ruling is there's going to be pushback. There will be pushback. We haven't heard of it yet. Again, this just started, so we're waiting for that pushback. And then the last is how much skill and initiative. Is it a high level skill job that needs that, right? So that helps them be an independent contractor. I will say that if you haven't, in our Ultimate Book of HR Checklist, we do have a whole section on independent contractors. And so we do have the economic reality test in there, but we also have the IRS 20 common factor test in there. We also have the ABC test. And my advice to you is use all three of them when you're making the decision, because the Supreme Court has really kind of basically said we have to do this on a case-by-case basis. There's going to be a general thing and that kind of stuff. So it's already set out there. And so with this one, again, pay attention, listen to us on our podcast, join our HR Community of One Facebook group. Just pay attention to that, because more information probably is going to come from that as well. So that's what's happening in 2023, right? So that's what's happening. In 2024, that's what's on the books right now, right? Those are the ones that are on the books, and we can see that they're changing and that kind of stuff. But we also have to think about what's coming up, right? What is being proposed? What should be coming up? What do we need to be paying attention to? So even though this is, hey, what did you miss? I also want to be paying attention, because a lot of these things have been put in movement. And this is the big one, right? Is it rude to interrupt yourself? I'm sorry. I needed to jump in here for a second. So Sam, our producer, wanted me to tell you of something that I have going on. And I wanted to start with, how do we excel in the workplace? So over the last probably 8 to 10 years, I've studied individuals and team performance at work. And I have found that those individuals who excel in their roles have one thing in common. It's the ability to consistently make the right behavioral decision in the moment. It's simple on one hand, but terrifyingly hard on the other hand. So how do we consistently make the right choices? We must ask ourselves the following 5 questions. What do I need to know to do my job well? What actions do I need to take to do my job well? What systems do I need to develop to create consistency in my day-to-day? Who can give me guidance when I'm not sure which way to go? And how will I stay motivated to do my job well? When we ask ourselves these questions, it helps clarify the direction we are going. As a leadership coach, I have helped hundreds of managers be better leaders. And I want to help you be better at your job. I'm offering 25% off my 6-month coaching engagement. If you're interested in learning more, reach out to me at email at team@hrstories.com, and we can get started right away. As you know, as HR professionals, one of the most important things we can do is to continue to learn about changes in employment law. So let's return to our podcast where I dive into the crystal ball. What's coming up? What should be going up? And don't forget, listen to the end of the podcast for a special announcement. Hey, Sam, was that okay? 25% seems to work. The overtime exempt ruling. And so here's kind of the timeline for this, just to kind of get everyone in the same space. So the fall of 2023, the Department of Labor proposed a new standard salary level of $1,059 per week. It used to be, or it still is right now, $684. Right? And so it's $684 now. They are proposing to break it up to $1,059, which is about $400 difference, right? So that's a big thing. That's per week. And so then they opened up for public comment until November 7th, 2023. And they got swamped. A lot of businesses, a lot of individuals, and a lot of people were like, wait a minute, we don't think this is right, or we think this is great. We need to do more of this. It needs to be higher. And so they are sorting through all that commentation right now. And the goal for them is their aim is to give us a final ruling in April of 2024. So next month. However, this process has been going on and there have been many deadlines that have been missed. In fact, they said they were going to put out the proposal last year at this time, and then they said, oh, we're going to do it again, right? And so they kept rolling it and pushing it. So can I say absolutely in April 24 they're going to do it? No, but we need to be paying attention to it because here's the thing that you should be thinking about right now in your organization. You may have employees, right? If you have employees that are exempt employees between $684 per week and anyone between $1,059 per week, right? That's the new proposed level. You need to start thinking about what are you going to do with those individuals, right? And so are you going to make them exempt by putting their salary over $160? I mean, $1,060? Or are you going to say, okay, well, I guess they're going to be overtime. Am I going to put overtime policies in trying to limit the number of overtime that they get? And so that's really a strategy. And so if you haven't reached out to your executive team, if you haven't talked to people about this, you really need to do. You really need to kind of go, okay, what are we doing? How are we handling that? I think this is a big one for companies. Now, what they originally proposed in their proposal was when that final ruling came down, we would have 60 days before it started. Now, I know a lot of companies reached out and put in the comments like, whoa, 60 days, a little too fast. We need to kind of figure this out. We're going to need 120 days, 180 days. So it'll be interesting how they roll this out, as well as where they end up on that dollar level, right? We don't know. It could go up to $1,100. It could go down to $800, $900. We don't know what they're thinking, what the crystal ball is, but something to be paying attention to if you haven't already started doing that. And again, following us at the Team of HR Stories will help us do that. And so doing that as well. And this is another one that's kind of, I got to say, snuck by. I had not heard of it until I started trying to do my research for this presentation. So the EEOC, the Equal Employment Opportunity Commission, has enforcement guidance on harassment in the workplace. And so really what this is they are going to propose and give us more guidance about what harassment in the workplace is. And you can go to their website and put in enforcement guidance on harassment in the workplace, and you'll get the whole document. They really lay it out about what is it. And there are really three main things that they're focusing on. Cover basis and causation, meaning was the conduct based on individuals' legally protected characteristics under the federal EEO statutes, right? And so in that case, they're talking religion, they're talking national origin, they're taking race, color, sexual orientation, sex by itself. Am I missing one? Genetics, right? All of those characteristics, they're looking at all of them and they're giving us really detailed explanation of, hey, what does that mean? And how does that look? And all that kind of stuff. So it gives us a better understanding of how we should apply this, right? And so I think when we read it, or when you read it, I think it's going to help you go, oh, so I need to think about that way, right? And so that's really going to help us there. And then the second thing was discrimination with respect to a term, condition, or privilege of employment. And so they talk about what is a condition, what is a privilege of employment, right? And so a privilege of employment could be benefits, it could be vacation, could be time off, it could be staff parties, right? All of that rolls in there, and paying attention, going, okay, where is that? How we can do that? Looking at all that stuff, I think becomes really important. And then the last thing, is there a basis for holding the employer liable for that conduct? And so they go through 4 different things. Was it the owner or a proxy that said it? Was it a supervisor that said it? And what is the liability for that? And now let's face it. Here's the liability. If your owner says it, or a proxy for the owner, or a supervisor says it, it's probably some liability there, right? And so it gets down lower that maybe there's other things that may not be, but for most of it, it is. So here's what's happened. They proposed this back last year. I don't remember when, but it was late. It was early last year. And they have the final ruling. So they did public comment again. And so their final ruling is supposed to come out in April, saying this is the guidance. And again, there's not a law change. There's no regulation change. They're just giving us more information on how we should interpret harassment in the workplace. So it's going to be a great resource for us to use to dive in there and kind of look at that and do that as well. So that's a good one to kind of pay attention to as well. And then this is another one. Not a big one, not a large one, but it may, if you have OSHA, a lot of OSHA inspections to do it. And so this is OSHA, again, the Occupation Safe and Healthy Administration. Their worker walk-around representation. So if this is approved, this could permit union representatives to participate in walk-around inspections, even if the work site is not unionized and the representative is not an employee. So an employee could, hey, go to OSHA, I'm an employee at your organization. Hey, I want this person, they're a union rep, to come in and be part of the walk around when you do your safety walk around in our organization. So that's what they're saying. I don't know. There's a couple things I'm like, really? So right now, right, the regulation says, the regulation provides an exception of good cause, prohibiting third parties from coming on site when they are reasonably necessary to the conduct of an effective and thorough inspection, right? And so you could hire a safety engineer to come in, or an industrial hygienist, right? Somebody to be there to guide OSHA and get that kind of stuff, right? And so we could do that. An employee could be part of that walk around. But this is allowing a union rep that's not really associated with the organization to be part of that, which could lead to more unionization. And so I don't know. I got both mixed feelings on this. And so again, right? So when I read all the articles on this, there's a lot of unanswered questions. What does it mean, right? And so I think, again, this is supposed to be released in the spring or summer of 2024. I would just kind of keep that in the back burner. Okay, I need to be paying attention to this, but I wouldn't panic at this point, because I think a lot's going to change as we move forward, and we're looking for that, and we're doing that and paying attention to that. All right, so let's talk about non-competes, right? And so the FTC and the NLRB are talking about not allowing non-competes, right? And so in 2023, the FTC proposed a rule that would virtually ban non-competes in the employment agreements, with limited exceptions for non-compete clauses and franchises or franchisees and certain non-competes relating to sale of a business. Meaning that if you're selling your business, then there could be a non-compete saying, well, you can't start another business up like this, which kind of makes sense, right? And so I do think, and I was having this conversation yesterday with somebody, I do think sometimes non-competes become way too stringent and really hurt the ability for that individual to make there. In the big case, I remember there was a grill cook, right? Somebody that worked in a restaurant, and they were a grill cook. They were a great grill cook. And they, for some reason, the restaurant said, well, we need you to sign a non-compete. And you can't work within 50 miles of our restaurant, which is silly, right? How is that person going to make a living? They're going to have to move. And is that fair? And that kind of stuff. So I think there's a mix in here. But so they, again, proposed this. This is how this works. They got public comment. And so they have planned to announce the final ruling in 2024. And the U.S. Chamber of Commerce, right, has already said they're going to sue them once it's been announced. So be prepared, right? So just be prepared, knowing that that may happen. But here's my recommendation. You do want to look over your non-competes if you have them and make sure they really make sense and they're not hurting the ability for the employee to make a living, right? And so grill cook's a great example, but you could have, look, I worked at a company titled QVC. And so QVC had non-competes for our host. So our host couldn't go over to HSN or couldn't go to one of the other things for a year. And that makes sense, right? Because that individual would be taking their fans to that other thing and then would reduce the amount of money being spent at QVC, right? So that kind of makes sense there. Now, for some of you, you need to pay attention to your state laws, right? Because some state laws, California in particular, are looking at banning non-competes overall. And so again, paying attention, looking at that, and doing that becomes important. All right, so let's talk about, I want to talk about two things. I want to talk about AI, and I want to talk about remote work. And the reason I want to talk about them, because I don't want this just to be an employment law update. I do want to talk about the things that are happening in HR that we should be paying attention to, that we should really know. And so let's think about the ways we can use AI, right? And so a lot of companies, a lot of organizations have been using it for applicant tracking systems, right? We're taking those applications, we're going through them and going, okay, what are the keywords and that kind of stuff. So we know that in a lot of cases, the EEOC is saying, well, wait a minute, those are a little biased. And so we have to be careful. We have to be there, but that's a way to use it, right? Assist with employee onboarding, right? And so think about this and think about the way the future is. An new employee has a question about something. They can go to your AI and say, hey, AI, I have a question about this. And they put that question in, and you've populated AI with the answers to all that, right? So it's like having somebody that can automatically answer the frequently asked questions. And so that could help board of that, teaching them, walking them through that process. And that way, if they have any questions, they can deal with that. AI can be used to help with bias reduction. It can also cause bias reduction, but there is a way by not having supervisors and managers go through resumes and that kind of stuff and have AI do it. There's a possibility we can reduce some of that human bias in there, right? And so AI can be a little more logical, and so we can reduce some of that. Employee performance and engagement. So couple two ways there. Managing the employee performance, right? Are they meeting their performance, especially for those that we can have a dashboard or metrics tied to? Then they could be like, hey, by the way, you're out of this metric or you're out of that kind of stuff, right? But again, right, that has a lot to do with us putting in objective terms, which are going to be different there. Task automation, such as resume scanning, writing internal documents. I know a lot of people that are using it to write emails, are using it to build or outline workshops, using it to write performance reviews, right? They put in information. I have an employee that's a meet expectations in this field. Here's the comments I have. Can you write me that performance review? So we see that stuff going on, right? And we're going to see more of that as well. Collaborative scheduling. I don't know. So this is the thing. When I think about collaborative scheduling, think about the National Football League. Up until probably 5 or 6 years ago, there were 2 individuals that would do the whole scheduling for all NFL, right? And think about how long that would take and all the variations they had to go through. And now it can be done rather quickly by using computerized artificial intelligence, right? And so kind of looking at that payroll processing, benefit management, employee monitor, learning and development. There's so many different ways that AI is going to impact our workplace. And so you have to be paying attention and going, all right, what are we doing? How are we looking at this? What are the ways we're going to do that? Right? So there are some benefits of AI. I do think there's a possibility, and I know it's going to improve efficiency. And so if you can create a system, right? If we can create a system, AI can actually do whatever that is, right? And so one of the things we look at is we build checklists. Can we build those checklists into an AI system that allows that process to be done much more efficiently than we're doing it, and maybe doing it off hours and reducing some of that hours we're working at, right? And so kind of doing that. It can help us reduce costs, right? Kind of cross there. And it can help us make better decisions as long as the information going into it is relevant information, right? Because we know that sometimes there's some limitations to it, right? We know there's limitations to it, and we know that it doesn't have all the information. And so we have to be really careful about it. The companies that are using it well are really giving it a pool of data to pull from to say, this is how we want to use it on here. It's not giving it full access to the whole world's data, because the way we do things in Wisconsin is going to be different than the way you do things in Florida, which is going to be different than the way we do things in Spain, right? And so kind of making sure we do that. And so one of the things I read was that executives and HR professionals say 88% of HR tools rejected qualified applicants. And so when you are doing that applicant or resume scanning, they may be skipping qualified applicants. One of the things that I'm looking at now, and I'm working on a workshop / presentation for one of my clients, is skill building in the hiring process. And so how do we do skill-based hiring? How do we do upskilling in an organization? And so one of the things we have to look at is not relying on knowledge and experience and education level, but looking at skill-based abilities and making sure that that person can do the job. There are major data privacy and cybersecurity risks, right? And so again, they're reaching out, we're putting information in, it's getting in there. So being really care. And then I think that really it's learning, right? It's still learning. A lot of people are using it. We need to use it to see how it's going to benefit us. To me, here's the bottom line. When it comes to artificial intelligence, the bottom line is this: use AI to help you increase the human connection, right? It's not a tool to get between you and the employees. It's a tool that's going to hopefully give us time to really connect with our resources, our employees, and our associates, our team members, whatever we call them, because that's the goal, right? The more we can be connected to them on a human level. I was doing a coaching today with a group of managers, and one of the managers was saying it's really important for them to make sure they're connecting with their employees, not just as professionals, but also not in their personal life. That doesn't sound right, but also making sure that they know and care and understand, like, where is that energy coming from? Why do they do what they do? Who are they working for? Understanding that. And so she was like, if somebody's homesick for a couple of days, I'll always send them a text and say, hey, so how's it going? You okay? Anything we can do for you? Right? And so just having that human connection will allow our managers, allow us in HR to get into a better place. So when you think about artificial intelligence, always keep that in mind. How can it help me have a better human connection, right? How can we do that on there as well? And let's talk about remote and hybrid work. This, oh my goodness, if you talk about something that's being continued to be debated and people are throwing facts from both sides out of it and like, oh, you get it. Underlying this all, I think, is a freedom and a flexibility that our employees want. They want that inflexibility. They want to make the decision like, you know what, it's going to be better for me to work from home today because traffic's terrible. There's a big accident on one of the major highways, and it's going to take me an additional 3 hours to get into work. Right? They want that flexibility. They really do. And so how do we build that in there? Remote and hybrid work is one way. It's not the only way, right? And so again, And so there's still a lot of debate between employers and employees. Haven't come down to, and I haven't read any clear, like, this is what we need to do. When I look at Gallup, right? And so I think Gallup, that they're doing a lot of research, they know their information. Most remote capable employees are hybrid now and want to stay that way. And that does, hybrid's different. Hybrid can be different if it's, maybe it's 2 days a week, maybe it's 3 days a week, maybe there was a company, I think it was Johnson & Johnson, I could be wrong, but there was one company where they said, look, these are our core weeks. These weeks, I think there was 21 of them. These are our core weeks. This is the weeks we need everyone in the office because we're going to be talking, we're going to be doing things, we're going to have major discussions. These are the ones. And then otherwise, that's up to you whether you're in the office or not. And I love that approach because it's a business approach. When do I need people in? How often do I need people in? Do I need people in? Right? For some of us, right? If we're in a restaurant or we're in an automobile or we're in a nursing home, we can't be like, oh, work from home, it'll be great, right? We need them in there anyway. But what can we do around that? So that was Gallup said. Gallup also said employers largely indicate they intend to offer hybrid work arrangements. So going forward, most employers are going to do it, not all of them. And we did a story on our podcast about this because there was a company out there. It was the company, now I can't remember their name, but it was a company out there. It was a software company. And they're like, you all need to be back in the office. This is not a request. This is not, you need to be back in the office. And they did such a terrible video of it. Oh, it was terrible. There are downsides to remote, especially for younger workers. And so what we're finding is that those individuals that are inexperienced in the workforce, remote's not the right place for them. And for some other employees as well, just don't have the discipline, not the right place for them. And so we need to take that into account. We need to think about that. And so I know a lot of organizations say, look, this will be a remote job, but we need you in the office for the first year so you can get to know other people and connect with other people. The people that are doing really well remotely are those individuals that already have long-lasting relationships. And they feel comfortable reaching out to people and connecting people either through Zoom or Skype or whatever, through the phone, they can do that. Now, here's the other thing is a lot of statistics are saying, well, employers are like, we need people back in the office. This is the only way. Productivity is slipping. Collaboration is slipping. Now, from my understanding, collaboration is definitely slipping. Productivity, depending on the poll, depending on the information, goes back and forth. But I do understand the need for companies to be like, we need to build collaboration. We need to come through this. We need to kind of figure that out. And so you have to figure out what works for your company, right? You got to go back and forth and go, okay, this what's worked for us. This is going to be beneficial. These are the things that are going to be good for us. And then kind of going back and forth in that. So again, follow us. We're going to continue to talk about this. If you haven't gotten our book, The Ultimate Book of HR Checklist, highly recommend it. There are over 70 different checklists that we're going to help you get HR right? And so it'll help you avoid costly mistakes. So many great things. You can go to hrchecklist.com and you can see all the information about it, or you can go to the team at HR Stories and check us out there. And so we do consulting, we do workshops, we do the podcast. Our goal really is, Chuck and my goal, when we got together, we're like, how do we help those small businesses get better at HR? And I know you guys have that same goal. I know you're out there working at that. And so keep working at it, keep doing it. Thank you for being here. I really do appreciate you being here today. Thank you for listening to the HR Stories podcast, where there is a lesson in every story. Please let us know if you like this episode by sending us an email at team@hrstories.com. Tell us what you liked about it. How can we make the podcast better? We're always listening to our listeners. Remember to send us your questions so we can answer them on our next podcast. Here's the big announcement. Time to save money on HR training. The team at HR Stories is giving all of our podcast listeners and viewers a 25% discount on all of our workshops and training. Go to the team at hrstories.com/workshop and pick the sessions you want and add the code podcast25 and you will get 25% off any workshop you choose. Thank you for listening.